Good morning. Bye. I hope that everyone is doing well today. This week, our topic for our sessions is based on credit agreements. So we have 4 parts. We also have recordings that are uploaded for you online. And if we don't finish, then you need to continue listening to the recordings, reading your notes, and obviously supplementing your notes with the textbook. Okay, so we're going to start with part 1. The law of consumer credit agreements. So in this lecture, what we're going to cover is the relevance of credit agreements and why a new credit agreement is needed, the objectives of the new Credit Agreement Act, and the application of the National Credit Act. And lastly, with part 1, consumer credit institutions and credit industry regulation. So with regards to credit agreements, the relevance of credit agreements. Okay, the consumer credit agreement is a particular type of contract, just like the sale of contract. So it is a special type of contract or a specific type of contract. So all these 6 requirements or all those 6 requirements that you discussed with Mr. Kruger need to be there in the background, but we are now speaking about a specific kind of contract where we have a debtor, a creditor, and the amount being lent or borrowed. Okay, and is therefore governed by the general principles of the law of contract. The National Credit Act has had impacts on the contract of consumer credit agreements. So the Consumer Protection Act does not apply to consumer credit agreements that are governed by the National Credit Act, but does afford some sort of protection to the creditor for the goods and services that are purchased on credit. So where there is no legislation governing a particular credit agreement, the general principles of contracts then apply. Why did we need a new Credit Act? So in the past, we had the Usury Act and the Credit Agreement Act, and it became clear that it created a dysfunctional credit market. And what caused it to be dysfunctional is that there was a lot of discrimination, there was a lack of transparency, there was limited competition, there was high costs to the credit of the credit agreement to the debtor, limited consumer protection, and it was an exploitative micro-lending economy. Some of the other criticisms that we received in our credit market was that it was fragmented and it was outdated. We were using legislation that caused this fragmented and outdated system that we were using. It was ineffective. Consumer protection was not there. It was not the paramount. It caused high cost of credit to the consumers, and there was a higher rise of indebtedness of consumers, and there was reckless credit behavior or lending by the credit provider, and also the consumer was not being faithful. So we needed a new Credit Act. The mechanisms in place were not sufficient to provide debt relief to over-indebted consumers, and a complete overhaul of credit legislation was therefore needed. And then the Usury Act and the Credit Agreements Act was then repealed by the National Credit Act 34 of 2005. So this is the act that we now currently use in South Africa. The National Credit Act established the National Credit Regulator and the National Consumer Tribunal, which we're going to touch on later in this session. So the Act seeks to regulate credit industry and promote and protect economic welfare of South Africans, to promote a fair, transparent, and competitive, efficient, and accessible credit market for all. It also prohibits unfair credit lending and credit market practices, and protects your consumers on the credit agreements that they enter into. It also encourages responsible borrowing, and it also discourages over-indebtedness. So reckless credit lending is also discouraged by this new act. In credit agreements, we have two persons that are the main players. We have the credit provider and we have the consumer. The credit provider basically is a person who supplies you with the goods and services under a discount transaction, an incidental credit transaction, or an installment transaction. A consumer, on the other hand, is a person whom the goods and services are sold to under a discount transaction, an incidental credit transaction, or an installment transaction. So these are the most vital people that have a role in your credit agreement. You can go ahead and read what the credit provider does and what the consumer does in the agreement. With general application, when does the Act apply? The Act generally applies to all credit agreements between parties dealing at arm's length, meaning that there must not be a relationship between the parties where one party is dependent on the other party. So examples of agreements that will not be at arm's length is where a company gives a loan to one of its shareholders, so the National Credit Act will not apply, or where a spouse gives out a loan to his or her spouse, the National Credit Act will also not be allowed to interfere with those agreements, or where a brother loans some money to his sister, the National Credit Act will not apply in those situations. So we know that the National Credit Act will apply to credit agreements that are performed at an arm's length. The National Credit Act even applies to credit agreements where credit is provided, firstly, by an organ of state or an entity controlled by an organ of state, an entity created in terms of any public regulation, and the land bank. Circumstances where the Act will not apply is where the consumer of the credit is a state or an organ of state, the credit provider is a reserve bank, and the credit provider is located outside of South Africa, and it's not approved, that agreement is not approved by the Minister of Trade and Industry. The Act will not apply. So the Act merely applies in situation where the consumer of the credit agreement is a natural person, and in rare instances, it will apply where the consumer or the credit provider is a company, a closed corporation, a partnership, or a trust. So certain parts of the Act apply where the consumer is a juristic person, but those are in very rare instances. The Act provides limited protection to small and medium juristic persons where the asset and turnover is below R1 million and who enter into a small or intermediate transactions and not your very large transactions. The best manner in which to determine if the Act applies is to ask these following questions. Firstly, is it a credit agreement defined in the National Credit Act? Does it relate to a credit agreement that was concluded between parties dealing at arm's length? Was the credit agreement concluded in South Africa, or does it have effect in South Africa? And lastly, are there any exemptions set out in the National Credit Act that say that or stipulate that the National Credit Act must apply? An agreement is generally a credit agreement if it has these two elements. Firstly, there is some deferral of repayment or repayment of money. And secondly, where there is a fee, a charge, or an interest which is opposed in respect to a deferred payment, or a discount is given when repayment is made. The Act specifically provides that a credit agreement will include the following: a credit facility, it can be a credit transaction, a credit guarantee, or the combination of the above. We're going to go into detail with each, and you guys need to supplement this with your textbook. What is a credit facility? An allowance granted by a credit provider to enable a person to purchase without having cash at hand. For example, a credit card. Okay, you're buying a car on credit, clothes using your credit card or a store card, or an overdraft facility on a check or a current account. A credit transaction could be a pawn transaction, a discount transaction, an installment agreement, an incidental credit agreement, a mortgage transaction, a secured loan, a lease on movable property, or any other agreement in terms of which the credit is granted for a fee, a charge, where interest is payable. A credit guarantee is an agreement that constitutes a credit guarantee in terms of that the credit agreement or the person in the credit agreement takes a surety agreement and undertakes to pay towards a credit provider to satisfy the demand on any financial obligation of another person. This should be, should a consumer fail to pay or honor his debts, then a surety will then be called to settle the amount that is due. So what we're talking about here, for example, if you want to go to the bank and apply for credit, and the bank says we want someone to sign a surety. So you ask your mother to sign a surety for you, and should you fail to pay the monthly installment back to the bank can then sue or ask that your surety, the person who has signed in your place, to pay the money on your behalf. A combination of the above example will be an installment sale of goods in respect of which payments are made by means of a credit card over a long period of time. Okay. Which agreements are not deemed to be credit agreements? Specific transactions and agreements are excluded from the scope of the Act and are not considered to be credit agreements. These include a normal policy for your insurance, a lease of immovable property, and a stockfile agreement. All these will not be deemed to be credit agreements. So in addition to the above circumstances, the Act also explicitly provides that in two specific instances, the transaction will not constitute a credit agreement, and therefore the National Credit Act will not apply. In the first instance is where the person is selling the goods and services and accepts full payment for it. It's not deemed a credit agreement. The second instance is in terms of Section 4, subsection 6 of the Act. If the consumer pays fully or partially for goods or services through a charge against a credit facility, and if the agreement provides that a supplier is supplying a utility or agrees to defer the payment by the consumer until the supplier has provided a periodic statement of account. This will impose any charges of interest in respect of the amount so deferred unless the consumer fails to pay the money that is due and paid up in full. There are different categories in which the National Credit Act would apply. It will apply to small transactions like your pawn transaction. It could also apply to immediate transactions or intermediate transactions, which are less than 15,000 Rand, or to large transactions that are over and above your 250,000 Rand mark. And finally, consumer credit institutions and credit industry regulation. How is the credit industry regulated? So in 2006, the Act established the National Credit Regulator, which is responsible for regulating the South African industry. Over and above that, the Act established the National Consumer Tribunal. This is an independent body and it's responsible for hearing matters where there is a dispute in a credit transaction or in a credit agreement between the credit provider and the consumer. Are there any questions so far? Any questions? Okay, let's move on to part 2 of the law of consumer credit agreements. So here we're going to be speaking about your consumer credit policy and consumer rights, and also credit agreements in general. So with regards to your National Credit Act, it gives basic rights to the consumer. For example, the right to apply for credit. So everyone has the right to apply for credit. Secondly, not to be discriminated against when you're applying for credit. So a person could be discriminated against because of their race, their gender, or their sex. This is not allowed by the National Credit Act. And if you do happen to apply and you are refused, you must be given reasons in writing as to why your application was refused. And those reasons must be given in one of the 11 official languages, and preferably the language of your choice and the language that you understand, because then they will have to give you the information in plain and understandable language. And should, for example, you apply for credit and you get the loan, then it must be in writing and you must receive all those documents. So copies of the contract, you need to receive all copies of the contract to say that you are in possession of them and it remains as proof. So the National Credit Act provides for protection of all consumer rights where people are entering into credit agreements. The National Credit Act also deals with pre-agreement disclosures. So where a credit provider is said not to enter into small credit agreement unless the credit provider has given the consumer a pre-agreement statement and a quotation. in the prescribed form. Also, a credit provider must not enter into an immediate or a large credit agreement unless it has given the consumer a pre-agreement statement and a quotation setting out the cost of the agreement. It also places an obligation on the consumer. So if you happen to buy something on credit, for example, a motor vehicle on credit, where a bank now finances your motor vehicle, you have an obligation as the consumer to inform the credit provider of any changes to your personal information. So until such time that the credit agreement is terminated, the consumer must inform the credit provider of the residential address. Say, for example, you've moved provinces, you need to notify of your residential address. You also need to notify the credit provider of your new business place. Maybe you had moved for the reason that you have changed jobs. You need to notify the credit provider. Where goods are kept. For example, if you have moved, maybe you moved together with a car, where now the car is kept in a different province. You need to advise the credit provider that has moved. The name and the address of the person that is in possession of the goods. So if, for example, you've left your car in the care of maybe your friend or your cousin, you need to inform the credit provider as to where the asset is. It also deals with pawnbrokers. So the National Credit Act will regulate pawn transaction. So the Act places specific obligations on pawnbrokers, and an example of a pawnbroker would be your Cash Crusaders, where you take a valued item and you give it to the pawnbroker, and the pawnbroker in return will give you an amount of money which you need to pay within a certain date. And should you get the money and be able to pay within a certain date, then the pawnbroker needs to give you back the item. But if you don't, then the pawnbroker has the right to sell the item to receive or to retrieve what is due to them. So the National Credit Act places an obligation on the pawnbroker to firstly specify the date on when the agreement needs to terminate. And secondly, the property must be kept until the termination date of the agreement. And lastly, if the settlement value is paid before the termination date, then the property must be returned as soon as payment is made by the consumer. So when you enter into a credit agreement, over and above your capital debts that you're paying back and your interest, there are other fees that are involved when you are now paying back the credit. Okay, so your principal debt, obviously you'd have to pay back the money that was lent to you if it was a borrowing and lending of money. Secondly, an initiation fee. You may be required to pay an initiation fee. You may also be required to pay a service fee. You also know that you need to pay credits most of the time where you attain credit from a provider. You may be asked to pay any credits for insurance or default administration charges or collection costs. The National Credit Act places an obligation on the credit provider to account to its consumers. So statements must be provided every month or every 2 months if it's an installments agreement, a lease, a secured loan, and every 6 months where it is a mortgage bond agreement, or upon request. And if the consumer happens to request for a statement, then it must be at no charge to the consumer. So the statement must then include, firstly, the current balance, how much is still owing by the consumer, any debts or credit. Okay, so if the consumer had asked for a 6 months statement, then maybe during that 6 months, he or she has been making payments towards the debt. Okay, it must reflect that some payments were made and when they were made. If the consumer had fallen into arrears, then those dates of arrears must be stipulated in the statement, and when exactly how much was in arrears must also be stipulated in the statement. Okay, the question is, can a person unilaterally terminate an agreement or a credit agreement? According to the law of contract, you cannot, or if there's a material breach, then you can. But the NCA, the National Credit Act, then provides an exception to the general rule provided for in the law of contracts that a party may unilaterally cancel an agreement for no valid reason. A consumer can rescind or terminate an agreement concerning the movable property if the agreement was entered into at the premises other than the business address of the credit provider. This must be done within 5 business days after the date of signature that you can terminate. The consumer can deliver a notice and then return the good, and the credit provider must return any money that was paid by the consumer. Surrender of goods. Can a consumer then surrender goods? The National Credit Act provides for the special process in terms of which a consumer may unilaterally terminate the contract and return the goods. What is the process? Written notice must be given to the credit provider, advising the credit provider that he or she is terminating the credit agreement. And secondly, the return of goods the goods must be brought back or returned within 5 business days. And 10 days after delivery of the notice, the credit provider must provide or give the consumer the estimated value of the goods. And 10 days thereafter, the consumer may withdraw or terminate the agreement. Thereafter, the goods must be sold as soon as possible at the best reasonably attainable price. And lastly, the proceeds of the sale would then be used to set off the consumer's account. Prohibition of certain marketing and advertising practices. So you'd find that the National Credit Act prohibits unsolicited marketing. What are examples of unsolicited marketing? Your negative option marketing, which means that a consumer will automatically be entered into an agreement, okay, unless the consumer then declines the offer, or it could be by way of harassment where the credit provider then attempts to persuade the consumer to enter into an agreement or solicit them at their home or their workplace, trying to induce them to enter into a credit agreement. Advertising practices are regulated by the NCA, and the size and position of special conditions in an advert for the credit agreement is prescribed and cannot be misleading and cannot contain the rates and costs that are not according to the National Credit Act. We also see that the Consumer Protection Act also deals with unsolicited advertising or prohibited marketing and advertising practices. Now we're going to deal with your credit agreement in detail. So the Act provides that an agreement must be in plain and understandable language, and the consumer has the right to receive it in one of the 11 official languages, and preferably the language that they understand best and the language of their choice. The Act requires the credit provider to make certain disclosures, although failure to comply with this does not invalidate the credit agreement. Credit providers do not comply with this run at a risk of being fined. Over and above being fined, they run at a risk of being registered and not being able to conduct services as usual. The Act then contains an exhaustive list of fees, charges, and interest that may be charged to a credit provider who then invades the Act. What is the format and the form of credit agreements? The exact form of the small credit agreements that the credit provider and the consumer would enter into is prescribed in terms of the regulations in the Act. With your intermediate and your large credit agreement, it's more flexible. The regulation prescribes information that should be contained in them, but it's not in their form. Credit provider must provide the consumer without charge with a copy of the credit document, which is printed or in a printable format. This document must then have plain and understandable language and must be supplied to the consumer in 2 or more official languages. Waiving of common law rights. Is a credit provider allowed to waive his common law rights, like the right of not disclosing everything about the agreement? The Act, the National Credit Act, prohibits a number of terms that are often found in your standard and in your standard term agreements, where, for example, you'd go to a bank, okay, and they'll give you a very thick contract to sign, and this contract comprises of standard terms. The only thing in the standard term that's changed is maybe your name and the amount of interest they're going to be charging you, because the amount of interest is accustomed to a person. So for instance, terms waiving common law terms such as your latent, defect, or limiting or exempting the credit providers from liability for pre-contractual misrepresentation or vicarious liability of its employees may not be included in credit agreements. So the Act completely forbids this and says that should you make a consumer sign a standard term contract all these terms that are in the contracts that are not easy to understand, they must be explained to the consumer in plain and simple language, so you cannot readily waive your common law rights as the credit provider. Section 89(2) of the National Credit Act states that an entire agreement is unlawful when, for example, the consumer is a minor, he's mentally ill, or subject to debt administration, and the administrator has not consented to the agreement, or where the agreement is as the result of negative marketing option or your unsolicited marketing options. Okay, the credit provider has not been registered, so he or she or it is supplying credit and is not a registered credit provider. The credit provider has ordered to stop offering the credit by the National Credit Regulator or the provincial regulator. The effect of the unlawful credit agreement is that the court of law must declare the contract to be void from the date that it was entered into. The Act also stipulates that a credit agreement must not contain unlawful provisions. So should the court not declare the entire agreement invalid, it can also declare a certain provision of the agreement invalid. So if a credit agreement contains an unlawful provision, that provision is void from the date on which the agreement came into effect. If the court found that the provision is unlawful, the court must firstly sever the unlawful provision, alter it to render it lawful if it is reasonable with regards to the entire contract. Or if it's not reasonable to have it in the entire contract, declare the entire contract unlawful from the date that the contract came into effect, and then amend the contract from the date that it had taken effect. Only an order of court can declare that a provision is void and not the National Credit Regulator. The National Credit Tribunal also does not have authority to do this. It's only the courts that have authority to do this. Capping of interest rates. What the National Credit Act does is that it caps the interest rate that can be charged to a consumer. So interest and fees that are charged to a consumer, they can be capped. The different maximum interest rates, your service fees and initiation fees will then apply. If it goes beyond the scope, then we'll deal with that case on a case-by-case basis. The court will deal with each matter on a case-by-case basis. We refer to 9.6 in your textbook for a short discussion on this. The Act also circumscribes the time period in respect of which statements of credit agreements must be approved. They vary according to the type of agreement it is, and where the consumer disputes any debt or debit or credit entry, then the credit provider must provide the consumer with written notice explaining the entry if it is correct, and if the entry is incorrect, then they must rectify the error and apologize, obviously, to the consumer. A consumer who has unsuccessfully attempted to resolve this dispute regarding a disputed entry through an alternative dispute resolution may simply then go to the tribunal to ask the tribunal to try and adjudicate on this matter and resolve this matter. Alterations made to a credit agreement after it has been signed are void unless the changes are reduced to writing or are communicated with the consumer. The credit provider and the consumer may also agree to alter some terms in the credit agreement, provided all the parties then agree to the alterations. The National Credit Act prescribes the procedure that's to be followed where the credit limit on a facility is to be reduced or is to be increased. Rescission and termination of credit agreements and surrender of movable goods. So parties to a credit agreement may terminate the credit agreement for different reasons and in different ways. Sometimes both parties fully perform in the obligations, while other times only one party will perform. Credit agreements commonly include a clause that gives credit providers an option to terminate a credit agreement where the consumer has failed to comply with his obligations. This must be done within 5 business days. For example, you can do this in your lease of mobile property entered into at any of the premises other than the registered business place of the credit provider. The provision is also made for a specific process within which a consumer in a certain credit agreement may terminate the agreement and surrender the goods to the credit provider if it is an installment sale, a secured loan such as a notarial bond over movable property, or a lease of movable over the instrument. So the Act also provides that the credit provider may terminate a credit agreement before the time specified, and in these instances, where the consumer is in default. So the credit provider must first give notice of the default and must suggest that the credit agreement be referred to either a debt counselor, an alternative dispute resolution agent, a consumer court, or an ombuds to try and resolve this dispute before them. So before they actually approach the courts, they must exhaust all other means that are applicable to them. A credit provider will also close or suspend a credit facility where the consumer is in default and must give written notice of at least 10 days before he closes or suspends a credit facility. Can a consumer then make early payments in order to complete the debt or paying the debts before time or the required time? So provision is made in the National Credit Act for a consumer to make early payments and the credit agreement and at any time without notice or penalty. The consumer may pay installments before the due date, and the credit provider is then obliged to accept these payments even if it's before the due date of the payment. Usually, your credit providers do not want you to do this because then you're killing off the interest. The National Credit Act also gives the consumer the right to settle a credit agreement at any time before its completion date by paying and settling the entire amount. Okay, let's now look at part 3 of credit agreements. And in this section, we will look at reckless lending and over-indebtedness of consumers. We will also look at prevention against abuse by consumers and debt counselors and debt review and restructuring processes. So with regards to reckless lending and over-indebtedness, the National Credit Act contains provisions aimed at protecting consumers against over-indebtedness or reckless lending by the credit providers. And one of the aims of the Act is to prevent consumers from being over-indebted, which is a result of reckless credit lending, either in the form that the consumers now provide credit, so the credit providers provide consumers with credit too easily, or the consumers keep asking for more credit. The National Credit Act makes it compulsory for a credit provider to firstly make an assessment of the consumer to establish whether they can satisfy their obligations every month. So a consumer will be regarded as over-indebted if, on the preponderance of the available information at the time that the assessment is made, it is indicated that he or she cannot fulfill the obligation at the end of the month. So you'll find that your credit providers will then do a means test before they actually approve you for that credit. When is the credit granted in a reckless manner? So credit agreement is reckless at the time that the agreement is made if the credit provider had failed to do this means test or this assessment to find out the means or the outcome, what the outcome would be, or if he failed to do so and just took it for granted that this person will be able to pay at the end of the month because they have a very good job. Okay, so secondly, the credit provider, having conducted the assessment as required, enters into an agreement with the consumer, despite the fact that with the information that's given, there's an indication that the consumer did not generally understand or appreciate the risk, the cost, the obligations that are under this contract that they're entering into. And that is why the Act then places the obligation on the credit provider to explain these terms in basic, plain and simple and understandable language. The credit provider is not allowed to enter into reckless credit agreements. And in order to avoid reckless credit agreements, the credit provider must take the following steps. Firstly, must ask the consumer whether he understands appreciates the risk and costs that are involved in his obligation and his obligation to this agreement. Secondly, the consumer's debt repayment history. Thirdly, the financial means, prospects, and obligations of the consumer. And lastly, whether it is reasonable to conclude at any commercial purpose for which credit will be applied for will be successful. The assessment procedures and protection mechanisms. So when a determination is to be made as to whether the credit agreement is reckless or not, a person making a determination must apply an evaluation criteria as existed at the time the agreement was made and without regard to the consumer's ability at the time the determination was made to meet the obligations under the credit agreement or to understand the risks, the costs, and the obligations under the proposed credit agreement. A consumer will be deemed to be over-indebted if, with the most available information at the time of determination, the consumer is unable to satisfy his obligation in a timely manner. Firstly, the consumer's financial means and prospects and obligations are not looking good. And secondly, probable tendencies to satisfy the obligations in a timely manner fails all the time. So the consumer will be deemed to be over-indebted. While the effects of reckless credit lending, so a court or a tribunal may declare the credit agreement to be reckless, and in such a declaration, the court will then set aside and say that the consumer is not obliged to perform in that agreement. And once the court has declared a credit agreement reckless, it must further consider whether the consumer is indebted. And if it finds that the consumer is indebted, the court may grant an order suspending the agreement and restructure the consumer's obligations under the credit agreement and other credit agreements that the consumer has entered into to allow the consumer to pay each and every creditor, even if it means less, but every month up until the debt has been absorbed. The effect of a suspended credit agreement. So if the court suspends a credit agreement, a consumer is not required to make any payments required under the agreement. If it's interest, fees, charges, the consumer is absolved from paying any of those fees. The credit provider's rights under the agreement or under any law in respect of the agreement are unenforceable at that time. A suspended agreement remains enforced but cannot be enforced until the consumer can afford to meet those agreements. So once the suspension period ends, the rights and obligations of both parties, the credit provider and the consumer under the agreement will then be revived and enforceable except to the extent that the court will provide otherwise. So the credit provider cannot recover any interest or charges or fees which were due to be paid by the consumer during the suspension period. Do you guys have any questions so far? Okay, now we're going to look at the prevention against abuse by consumers. So you'd find that sometimes consumers will abuse the system and they won't give adequate information or the correct information. So in order to prevent consumers from abusing reckless lending provisions specified in the Act requires that a consumer supplies the credit provider with the most fully and truthful answers as requested by the credit provider whilst the credit provider is doing the assessment. So the Act provides that it is a complete defense against the accusations that the credit provider is reckless if, firstly, the credit provider establishes that the consumer has failed to answer fully and truthfully any request for information. Secondly, a court or a tribunal determines that the consumer's failure to materially materially affected the ability of the credit provider to make a proper assessment. A consumer will not be able to benefit from a reckless lending provision if he or she did not disclose all the correct information to the credit provider. And in this case, the credit agreement will not be deemed to be reckless. It will not be terminated. It will not be suspended as well. And all the obligation under the contract, the credit consumer will be then obliged to pay and perform in terms of that contract. Lastly, for part 3, we're going to look at debt counselors and debt review and restructuring processes. So the National Credit Act provides for a formal debt restructuring of debt by a court for a tribunal or by consent of the parties that are to the agreement. And the Act provides for a debt review in cases of a consumer being over-indebted. A consumer may apply to a debt counselor to have himself declared over-indebted, or apply to a court or a tribunal so it can refer the matter to a debt counselor. So a debt counselor will evaluate the consumer's circumstances and make a report to court indicating whether or not, firstly, the consumer is indebted or over-indebted, and secondly, certain credit agreements are reckless, or thirdly, declare that the consumer is over-indebted and make the appropriate order to relieve the consumer from being over-indebted. And if a debt counselor then makes a proposal to the court or the magistrate court, or the consumer applies to the magistrate court, the court may reject the proposal or make an order declaring any credit agreement concluded by the consumer to be reckless, or make an order to rearrange the consumer's obligations. The duties of a debt counselor are then to provide the consumer with proof of receipt of the application for the debt counseling. Secondly, to notify in the prescribed manner and in the prescribed form all credit providers that are listed in the application in every credit bureau. And thirdly, if a consumer requested, then the credit provider or the debt counselor must investigate any agreements or any other agreements that the consumer has entered into to try and find out if those agreements were not recklessly entered into. And lastly, a debt counselor must determine whether or not a consumer is over-indebted and make the appropriate recommendations to the magistrate's court. If a debt counselor has to decide whether or not a consumer is over-indebted, you must consider whether a consumer's total monthly repayments exceed the balance derived by deducting its minimum living expenses from its net income. A debt counselor is under a general duty to refer unresolved debt review matters to the magistrate court, and the court must then conduct a hearing to determine this matter. Where a consumer is in default under a credit agreement that is being reviewed by a debt counselor, the credit provider may provide a notice to terminate the review in the prescribed manner to the consumer and the debt counselor and the regulator, provided that firstly, at least 6 days have passed since the application of the debt review, and secondly, the debt review has not already been filed with the court or a tribunal. The credit provider may thereafter proceed with enforcing the agreement, but a court hearing the matter has discretion to order the resumption of the debt review and conditions it deems just and appropriate at that particular point in time. So a consumer whose debts have been rearranged or restructured in terms of the Act may insist that the debt counselor issue them with a clearance certificate, where firstly, the consumer has fully satisfied his obligations under the agreement, or where the consumer has demonstrated financial obligation or ability to be able to satisfy his debts in the future, and where there are no outstanding arrears or debts in the arrangement. So a credit bureau is obliged by law then to display the information, provided that you give them a clearance certificate. And once you do that, then your debt will be cleared from the system of the credit bureau. Do we have any questions, guys? Any questions? Okay, with the 5 minutes that we have, let's look at part 4. All right, so in part 4, we're going to look at legal debt enforcement and alternative dispute resolutions, search warrants and enforcement of the Act, miscellaneous matters and other governing consumer credit agreements. So previously, the micro-lending industry had started to use extreme and unregulated money collection procedures. For example, lenders will take and hold consumers' cards and pins, and at the end of the month, they will take it upon themselves to go and withdraw some money, and how much is what they will decide. The practice was abolished in 1999 with the exemption of notice, and today is strictly prohibited by the National Credit Act. The National Credit Act sets out a very detailed and stringent procedure that the credit provider needs to follow when he wants to collect debt from a defaulting consumer before he actually institutes legal proceedings. So before the credit provider even approaches the court, the credit provider is supposed to prepare what is called a Section 129(1)(a) notice. It's basically a letter of demand demanding payment from the consumer. Okay, this notice will draw attention to the consumer to the fact that he has the right to various alternative dispute resolution methods. For example, your debt counselor, your dispute resolution agent, your consumer court, or ombuds with jurisdiction, and before the credit provider can go and institute civil or legal proceedings in the court. In addition, the Act also provides a detailed procedure to be followed by the credit provider when a consumer elects to utilize his statutory right to terminate and surrender the goods in terms of the installment agreement or a secured loan or a lease. The main purpose of Section 129 is to place a duty on the credit provider to inform the consumer of any other possible assistance that the consumer can utilize before the legal action takes place. So in general, a credit provider may not commence any legal proceedings to enforce the credit agreement before sending out a Section 129 notice, and this notice is usually sent via registered post, or it is delivered personally to the person in their location or designated area. Maybe it could be their workplace. So before a credit provider can take legal action on the consumer, they need to make sure that the consumer is in default for at least 20 business days, and at least 10 business days must have lapsed since the delivery of the notice and the consumer has not responded or has rejected the proposal in the Section 129 notice. The credit provider receives a notice of court with regards to the proceedings, the suspension of the agreement on the ground that it is reckless or is alleged to be an over-indebtedness situation, or receives a notice from a debt counselor of an application for debt review that a consumer has lodged. The credit provider may then not exercise and enforce any judicial process at that time, and any right or security under the credit agreement will be terminated until this matter has been resolved by the credit tribunal. However, if a credit provider wants to take legal action against the consumer that is in debt or is under debt review, he may also do so if he first terminates the debt review in terms of the National Credit Act. The courts will not allow the execution or the attachment of a person's home without firstly taking into account Section 26 of the Constitution of the Republic of South Africa. And this section gives a person the right to access to adequate housing. So the Act specifically promotes the use of ombuds and other alternative dispute resolutions before approaching court. The Act also deals with procedures for initiating complaints or making applications to the National Credit Regulator or the National Consumer Tribunal. And remember, the National Consumer Tribunal is the correct forum or the best forum because it usually deals with disputes arising from credit agreements. Let us look at search warrants and enforcement of the Act. So the National Credit Regulator plays a vital role in ensuring that the Act is enforced, and certain sections in the Act make provision for issuing of warrants of execution so that the premises of the credit providers may be searched. It specifies the entry and search procedures. The Act further stipulates the offenses that may be committed and the maximum penalties and gives the court discretion in this regard. So by the time the matter goes to court, it has been dealt with by the National Credit Regulator. In terms of miscellaneous matters, the National Credit Act stipulates requirements that must be complied with when a credit provider or debt counselor or payment redistribution agent makes use of other persons or conduct business in terms of the Act, and it is their duty to ensure that the agents or the employees are trained with regards to these matters according to the Act. Okay, and lastly, other legislation governing your credit agreements. The National Credit Act is not the only piece of legislation that we must consider when we're dealing with credit agreements. We also have the Alienation of Land Act, because usually people buy land and they ask the bank to supply them with a loan. So we have the National Credit Act coming in there, and we also have the alienation of land there. Remember that we're dealing with a consumer, a person is buying something. So we also have the Consumer Protection Act that plays a vital role. So when we talk about your consumer agreements, your credit agreements, we also consider the Alienation of Land Act, and we also consider the protection of a consumer under the Consumer Protection Act. Okay, the Alienation of Land Act specifically deals with the sale in the land and installments where the purchase price is payable in 2 or more installments over a period of time. And your Consumer Protection Act affords the protection to consumers for all goods, services purchased by the consumer, irrespective of whether the goods or services are subject to a credit agreement or not. It also governs the marketing, promoting, and supplying of any goods or services that are supplied or offered on credit and is in the form or subject to a credit agreement. Okay, and that brings us to the end of our session today. We've covered all 4 parts, but I encourage that you guys read the notes, supplement the notes with the textbook, and send me an email, ask for a one-on-one consultation if you do not understand any of the concepts or anything that has been discussed in the lectures. Otherwise, thank you so much. If there are no questions, we will end the lecture here for today.